coming in today. We are going to start with our karakia, so please join in if you wish to. Whakataka te hau ki te uru, whakataka te hau ki te tonga, kia mā ki ina ki uta, kia mā taratara ki tai. E he ake ana, te atakura, he o, he hoka, he hauhu, ti hei mauri ora. All right, just a little bit of a recap. We are going to go, Mr. Hewison and Dr. Gordon are both online, so if you are speaking, can you please make sure that you are using your microphones and that you also right by it. So we're going to go first to the legal submission. That was Exhibit F that we were given yesterday in the afternoon. So we're going to go now to Mr. Hewison. Are you there?
Kia ora. Can you hear me okay, Madam Chair?
Yes, we can. Thank you. Please go ahead.
Excellent. So I do have a preliminary matter that's probably worth raising now. Yesterday, during Ms. Kelly's evidence, you asked her about occurrences of alcohol-related harm in and around the Whānau Centre. Overnight, she's recalled more details about two events, and if you're Chair, if you're minded to hear from her, it might be something you wish to do, and you could recall her to relay those specific examples to you perhaps a bit later in the morning, maybe following these opening submissions from me.
You noted, I'll just talk to the committee about that and we'll come back to you. Is that okay?
It's excellent. Yeah, look, I will be handing it over to Dr. Gordon after my submissions, but she's aware of the situation and I'm sure she can assist you with that.
Thank you. We'll come back to it.
Thank you. So turning to the submissions, what I'll do is just take you through the kind of key points and paragraphs and not try and take up too much of your time today. So perhaps if we just leave the introduction, I think that's relatively straightforward. And then if we go over to the next page, we'll leave the summary perhaps to come back to. So in terms of the statutory criteria and case law, my friend has set that out. What I would like to emphasise, though, paragraph 12, I've included some of the background to the new Act, or to the 2012 Act, from the Court of Appeal and the Supreme Court decisions in the supermarket cases. And while those decisions regarded a lap, they've provided a very good background to what this Act was meant to achieve. And in particular, make the point that the old Sale of Liquor Act was an experiment that the Law Commission had reported on and said it had failed, and that we needed to move to a new regime that was much more proactive and that would achieve a reduction in New Zealand's serious alcohol-related harm issues. So I've got a little snippet of that, but you're very welcome to go and look at the background of both of those piece of legislation. But the key point is that this new Act is about a new regime. It's about minimising alcohol-related harm, and we have now Supreme Court and Court of Appeal really emphasising that's the approach that should be taken. Just wanted to refer to my friend's, Mr. Millimus's submissions, where he made the point that general evidence is a matter that has been raised by applicants as being of a concern, but here we have very specific evidence, particularly the evidence of the agencies, which you'll hear later today, is very specific about this store and about the impacts on the locality from this store. Equally, the objector evidence, Ms. Kelly's evidence was quite specific. Ms. Hannafin's evidence and the photographs that she managed to take of people drinking outside and of people purchasing alcohol and bringing it to drink outside and share with others is very specific evidence. And evidence, I'd have to say, in terms of my experience in this field over a decade, is almost unique. I can't recall seeing evidence of people coming out of a liquor outlet with alcohol and then proceeding to consume it, especially in an alcohol ban area. So I think just in terms of that general versus specific, you have here very, very specific evidence that I think is important to emphasize. My friend's been over a number of the kind of key principles that I've raised as well in paragraphs 13, 14, and 15, so I won't labour those, but I do want to just emphasize that the DLC should expect an applicant to put its best foot forward. And certainly in terms of the sales information, revenue information, I think the applicant really has let themselves down there in terms of multiple attempts to provide that information, and that information still in my submission being inadequate in terms of what the Act and the case law requires. Turning over to the next page, paragraphs 16 to 19, just emphasising there again that there is a variation, and that does trigger a number of matters, particularly matters in the LAP, which I'll get to a bit later. So we're dealing with not only Section 131, but 120, and through that, Section 105. Of importance to this application, as they are with all grocery stores, is the question of whether the premises should hold a grocery store style off license, or whether that license should be renewed. It's probably important there, again, to emphasize the background. So paragraphs 21 through to 22, there was a proliferation of the sale of alcohol from dairies under the Sale of Liquor Act, and that raised a number of concerns throughout the country with the community, but also with the agencies. And in its report, again, the Law Commission recommended very strongly that these approaches and rules and how we regulate whether a grocery store is a grocery store or whether it's a convenience store, whether those should be tightened, and those recommendations were agreed with by Parliament through not only the Sale and Supply of Alcohol Act, but also the regulations that have been made under that Act. And I just want to emphasise in Section 36 of the Act, there's a specific prohibition on the sale of alcohol from convenience stores. So Parliament's been very strong in its view that it does not want convenience stores selling alcohol. And as you heard yesterday and in these submissions, it's the submission of the objectors that this is a convenience store. It has all the characteristics of a convenience store, and the applicant has not shown you for this to be a grocery store. I've set out some detail around that. It does get a little complex, but that's how the Act provides for this, and that's how the regulations provide for it. The Westlaw commentary is quite helpful in terms of what is a convenience store and the background of some of the key cases in relation to that. And I won't take you through all of the detail, but essentially the key points that come from that case law is around the type of store, its size, its layout, whether it has a kitchen, and there appears to be a proposal which has just come to light of there being a kitchen proposed in this store, which would indicate that it's more of a fast food convenience style store than a grocery store, and whether it sells, what the types of goods it primarily sells. So if it's selling lots of lollies and slushies and kind of fast food type, or food that's taken out of the store to be consumed immediately and not taken home to be cooked, then that shows you that this is more of a convenience style of premises than a grocery style of premises. And I've set out some of the case law around that as well. Turning to grocery stores themselves, again, the Act is really prescriptive about how you should approach this, particularly in sections 32 and 33, and I've set out what those are. But again, it reinforces those points so that you must have regard to the size, layout, and appearance of the premises. So when you walk into the premises, as the agencies and the objectors have set out, it appears to be a convenience store. It's not until you get further back in the store that the grocery items start to appear. The statement of annual sales revenue produced in accordance with the sale and supply of alcohol regulations are important. The number, range, and kinds of items on sale, and any other matters that you may think fit. So that's your key task in terms of determining whether this is a convenience store or a grocery store. Turning over to paragraphs 29 through to 31, I just wanted to emphasise there that these statements of sales revenue are very, very important. In the two cases I mentioned, Medical Officer of Health and Uday and Tricorp Holdings, the authority essentially said that these are of fundamental importance, these statements of annual sales revenue, fundamental importance in terms of determining whether the premises are a grocery store. They emphasised that further and said that this assumed an elevated mental, and that Parliament had elevated this part of the criteria and to that elevated level for you to have to consider. Again, just reinforcing those requirements in terms of the appearance of the premises and what products they sell, and fresh fruit and vegetables and so on. And also whether this is a destination where people purchase grocery items to take home, down in paragraph 32. And we have here a situation where the super value appears to be much more of the small supermarket, clearly grocery store in this community, and that they tend to shop there for those sorts of grocery items. And as a consequence, I think it's useful or important to whether this is a convenience store. So it appears there's clearly a grocery store, maybe of a small supermarket in the set of shops, and that this store is acting more in the nature of a convenience store by comparison. The statement of annual sales revenue, paragraphs 33 to 36, I've just included the three sets of information that were provided to you. And as you heard yesterday, in terms of an evaluation of those, there was admissions from the applicant that they weren't meeting the requirements that are set out in those regulations. So I've set those out in paragraph 37. So they're not meeting the regulations, and in my submission, that means that you don't have that information in a manner that would meet the elevated mental or would meet that higher standard. So it's the evidence before you in the submission of the objectors that you cannot find this to be a grocery store in terms of the statement of sales revenue. The evidence just isn't there in a way that would give you confidence that it meets that set of requirements. And then in terms of the characteristics, as I said earlier, the characteristics of the store is particularly when you walk into it, it's a convenience store. It sells those kinds of convenience items. And the applicants put in place a slushy machine, and it's looking to put in place a kitchen that would further reinforce that style, whereas the super value is the store people go to buy groceries. So overall, on that basis, the submission is that this is not a grocery store license. And if it fails on that test, then all the rest of the tests that follow on in section 131, 105, and 120 in a way don't apply. So you've got to meet the first test before you get to the rest of the tests. So in our submission, the applicant doesn't meet that first test. In terms of vulnerability, deprivation, extended suitability, I've just set out these requirements and the evidence in paragraphs 41 through to 47. But essentially, overall, I don't think anyone here is saying that this is not a vulnerable community. Certainly, the deprivation data provided by the Medical Officer of Health, who I'm sure will expand on that today, is clear. And so are a number of issues that would indicate vulnerability, such as the rough sleepers, the bigging, and so on that's going on immediately outside of the premises. There's also the case that Dr. Palmer mentioned, Fantame liquor, where the authority found that this was a vulnerable community. So I think you have confidence that no one's denying that this is a vulnerable community. Therefore, the higher threshold of extended suitability applies. And in the objective submission, the applicant doesn't meet that higher threshold of suitability. Again, the statements of accounts do not provide, and you haven't been made to that higher level. The applicant has been selling singles of low-priced, high-strength beer. The applicant, as we found yesterday, is not thoroughly aware of the conditions of their license. In my submission, they are in breach of condition F. I think condition F is clear that there are two parts to it, but especially the most important, in my view, is it makes it clear that the breaking down of larger packs, such as a 12-pack of Heineken, into singles to be sold, that's what that condition seeks to avoid. And I think in my submission, in the objective submission, there's a clear breach of that. That is a matter that goes to suitability. So that is a matter before you and can, in my view, should be determined by you. There's no need to go off to the authority to enforce that condition, where in an application for renewal, that's clearly an issue for you. And that the applicant has also sold alcohol using Afterpay. I didn't have an opportunity to refer to this yesterday, but there is a decision of the Auckland DLC, which I'd be happy to provide, that raises serious concerns about the use of Afterpay at the Bottolo Panmure. And in that case, I understand that the applicant withdrew the use of Afterpay at that bottle store, but the DLC decision, I think, was useful in giving you some confidence that Afterpay is also goes to a question of suitability. We discussed the local alcohol policy yesterday, in particular this requirement in the objective submission that an impact assessment was required because of the variation, and that hasn't been complied with it. So there is essentially a non-compliance with the LAP in terms of that requirement. The design and layout of the premises, here I think useful is that the work that Ms. Hannafin referred to, and I understand that she's provided you the answers to your question yesterday about the average, the median and mean of the percentage of floor area, and even with a reduction, this premises has a large single alcohol area in terms of comparison with some other grocery stores through that study. In terms of amenity and good order, you heard evidence yesterday from the objectors, and you will hear evidence, I'm sure, today about a number of amenity and good order issues, but probably primarily is that nexus where this premises sells alcohol that is then taken out into the alcohol ban area, and within 20 metres of the premises, people are consuming alcohol in breach of that alcohol ban. And there's a number of other issues that go to the question of amenity and good order, but essentially the submission there is that if you refuse this licence under Section 131, then the amenity and good order of the locality would be likely to be increased by more than a minor extent following that refusal. There's clearly the evidence of Ms. Kelly. In terms of 131 and the sales, display, advertising and promotion of alcohol, again, concerns about the sale, promotion of high-strength singles, and then just normal strength singles in this premises at cheap prices. And the authority has, on a number of occasions, frowned upon and has refused licenses where there has been a sale of single sales of beer products, particularly those that are high strength. Turning to the system staff and training, again, some concerns that arose yesterday in terms of what appears to be a lack of a training documents that the inspector wasn't able to view those, and some key requirements around amenity and good order that there doesn't seem to have been training undertaken to assist staff with. The agencies, the Medical Officer of Health and the Inspector are opposed to this renewal, and that's significant in terms of your evaluation. And finally, in terms of the object of the Act and purpose of the Act, renewing this application and the objective submission would not meet the object of the Act. It would not minimise harm. And in terms of the purpose of the Act, the premises is not to the benefit of this community in the way it operates. And again, particularly for both of those, you have this clear nexus between the sale of alcohol from this premises and its consumption in a liquor ban area immediately outside and beyond that. So in this case, there is that very specific evidence that the renewal of this licence, even with the conditions being offered, won't meet the object of the Act or the purpose of the Act. So in conclusion, committee, the objector asks that the DLC decline the application to renew this licence. Thank you.
Thank you. Mr. Hewison, are you around now to answer any questions?
Yes, I'll be free. That was my plan, so I'm free to answer any questions.
Thank you. In that case.
Thank you. Just in relation to the afterpay, I understand there's been an offer by the applicant to remove that for alcohol sales, but it would also be helpful if a decision on that Auckland DLC decision could be provided as well. Thank you. In relation to the local alcohol policy, actually, I think one of my colleagues has a question about that. I'll let him ask that shortly, but I just have another one about the relevant legal provisions that are applicable for this application. It's an application for renewal, so normally you'd look at section 131 and the criteria in there. That refers to section 105, but not all of the criteria in section 105. But I understand that because there's a variation, which is the decrease in the single sale alcohol area, that then kicks in section 120, which requires consideration of all the criteria in section 105. So are you effectively saying that section 120 is overriding 131 in relation to considerations for the entire application? Is that correct?
It's slightly more nuanced than that. So my understanding of how those two sections work is they sort of work in parallel. So 131 deals generally with the renewal, but where there is a variation, then 131 deals with the aspects of the renewal that also involve the variation. We have a situation here where the variation is seeking to reduce the size of the single alcohol area, and although that triggers 120, you've got to consider 120 in light of the relevance of that. As I said earlier, although it's been reduced, it's still a large single alcohol area in the objective submissions compared to single alcohol areas for other grocery stores. So I think the way I would put it is that 120 and therefore the LAP are triggered because you essentially have still a large single alcohol area for this premises, and in my view that then triggers the assessment requirement.
Okay, thank you for that. And just to clarify, and I think your submissions do answer this, but in terms of the suitability, I understand that the whānau centre, a ground of their objection wasn't suitability, but that is still a criteria that the committee needs to consider, and the submissions are just being made around that as opposed to being an actual ground of opposition.
Yeah, I'd say that the objection made by the whānau centre raised issues of suitability, but not, with a heading and a clear title that said suitability, and these are the issues that we're raising under that particular title. But as you'll know, suitability is a very broad concept. It goes to issues of character. It goes to issues of the way that premises is operated. It goes to the kind of style of management, and the whānau centre were essentially saying at a number of occasions in their objection that they were concerned about the way in which the premises were, or its management, and the effect of that on the locality, in particular the effects on amenity and good order. So my view would be that they did broadly raise issues of suitability, but just not as specifically as I've seen in other objections.
Okay, thank you.
Do you have a question?
Just one question on the alcohol prices, and some of the submitters have said that it was the unit was attracting people because of the prices. We've now seen that the prices have not only been increased, but the price comparison charts that we've been shown suggest that that's not so. So is that still an objection?
I think it's important to just note that we are dealing with a renewal that with the premises having been operated and managed by the applicant over a 2-year period. So I think the objection needs to be taken in light of this was the experience over that 2-year period, and pricing certainly was an issue over that 2-year period. And then we've very recently had this change in approach from the applicant to adjust their prices, but that hasn't been the history of the premises. The history over the last couple of years is that those prices have been cheap, and now they've been adjusted to increase them more in line with what the supermarkets are saying. So I think that concern remains, despite the adjustment. That might be the case going forward if you are mindful to renew the licence.
I'm going to go to Mr. Middlemas first.
Sorry to interrupt. I just have one more question, which my colleague did raise yesterday with us. In terms of the local alcohol policy, there is the clauses. Clause 7.2 has been referred to. There's also clause 7.2E. Yesterday I referred to clause 7.2D, but there's also E, which talks about the sensitive site impact assessment, and it says that the alcohol licensing inspector will determine if an impact assessment is required. Evidence yesterday was that there was no requirement to do that, and so I just wanted to know what the response was for the whānau centre in relation to that clause.
I think that is a matter for the inspector, that particular clause, but the clause that I'm referring to appears to require an impact assessment by the applicant.
Okay.
But that may be something that you wish to raise with the inspector and have their clarity on that.
It will be raised with the inspector, but given that it's being raised by the objector, it's good to know also the response to that. But thank you.
Yeah. So essentially, I stand by the submission that I've made in regard to that. The other, I think it's D, the other clause, not the clause that you've just referred to. Yeah.
Okay. Thank you.
Thank you.
Morena.
Just Madam Chair, these are legal submissions I've given, and I'm not subject to cross-examination by my friend.
No.
So I would oppose any questions being raised by Mr. Middlemas. He has the opportunity to provide you closing submissions, which I'm sure would counter any points that I've raised, but it's not. Yeah, I would oppose being cross-examined by Mr. Middlemas. Yeah.
Mr. Middlemas is agreeing to that, and there will be an opportunity given for written cross.
Yeah. Written closing.
Sorry,
yeah.
written closings. Yeah.
Thank you.
I just understood that maybe was there a question for me though? Rather, I'm not going to question Mr.
No.
No. Okay, very good.
Oh, Well, we actually did have a question for you while Mr Hewison is here in regards to the request for Ms Kelly, and we actually wanted to ask
Yes.
you, as the applicant solicitor, whether you would be comfortable with that.
Well, I mean, we'll probably just take a minute to get instructions. Yeah.
Yeah.
I think my instructions are that we will abide the decision of the DLC, but that just to raise concerns that it does involve new evidence that we've not had a chance to see and we haven't had a chance to prepare cross-examination in relation to it.
Yeah, we'll take that on board. We'll be discussing this during morning tea time anyway.
Thank you, Madam Chair. So I think if you're comfortable, I'll take my leave and pass the rako to Dr. Gordon to support Ms Kelly for the remainder of the hearing.
Thank you very much, Mr Hewison.
Thank you very much. Ka kite, mate wā.
Everybody gets a question. Oh, for the count. Lawyers. Written submission. Yeah, I'll just go.
Thank you. Now, I will now invite Te Runanga o Tō Rangatira to present their objections and any relevant evidence. Mr Stewart and Ms Tikingi. We'll ask the advisor to administer the oath or affirmation.
I, Nick Mokomoko Stewart, solemnly and sincerely, truthfully declare and affirm that the evidence I'm about to give touching the matters before this committee will be the truth, the whole truth, and nothing but the truth.
I, Hinamo Metikingi, solemnly, sincerely and truthfully declare and affirm that the evidence I'm about to give touching the matters before this committee will be the truth, the whole truth, and nothing but the truth.
Tēnā koutou, tēnā koutou, tēnā koutou katoa. Ko Nick Mokomoko Stewart tōku ingoa,
Ko Hinamo Metikingi taku ingoa.
and we are here today representing Te Runanga o Tō Rangatira and Ora Tō Health Services. We appear before you in strong opposition to the renewal of the off-licence at 194 Bedford Street in Cannons Creek. Our submission is grounded in the kaupapa of protecting the health and well-being of our community, particularly in relation to the ongoing invisible harm caused by alcohol. Te Runanga o Tō Rangatira is the mandated iwi authority of Ngāti Tō Rangatira, and Ora Tō is our primary health service and community health provider. Our collective responsibility spans health, political, economic, and social spheres. Through this kaupapa, we are charged with protecting the mana and the well-being of our people and ensuring that decisions are made within our community reflect the realities on the ground. Our objection is not abstract. We live and work in this community, and we see the consequences of alcohol harm every day. Cannons Creek is one of the most vulnerable suburbs in Porirua. It is predominantly Māori and Pacifica and is already saturated with alcohol outlets. The harm that creates is visible in our clinics, on our streets, and in our homes. We hear concerns from whānau and we see the nighttime disorder, and we carry the burden of ongoing impacts on mental health, emergency services, and community safety. As stated in the evidence that was provided by our tumu whakarei, Helmut Modlick, I have seen the results of the drunken behaviour within Cannons Creek and the impact that it is having on the well-being of this community. These services in Cannons Creek pick up the pieces of the problems created. Not only do our medical practitioners deal with the harm that alcohol causes, but this harm also places services which are already under pressure under even more pressure. However, this is not just our anecdotal experience. It's well supported by experience and evidence from the World Health Organization, the Ministry of Health, and the Health Promotion Agency, all of which identify the increased alcohol outlet density directly correlates with the increased harm, especially in low-income communities. We know that Māori, and particularly Māori men, are more likely to suffer serious health consequences from alcohol, including chronic disease, injury, and early death. As a health service provider, we are actively treating the effects of alcohol harm. We deal with injuries, the mental health crisis, and intergenerational trauma, and the strain that's on our whānau. We understand that Section 4 of the Sale and Supply of Alcohol Act 2012 make it clear that the object of the Act is to reduce alcohol-related harm. We do not believe that this outlet meets that requirement. We ask the committee to consider, does the continued operation of this licence reduce the increased harm in our community? Allowing the licence to be renewed sends a message that harm is tolerable and if compliance is technically met. It undermines the intent of the legislation and the trust our community places in this process. In other parts of Wellington Region, licences have been declined on the grounds of alcohol-related harm. And why should our community be treated any differently? We are not here solely to oppose. We are here as partners and to offer solutions. We believe that there is an opportunity to do better, to reduce the availability of cheap alcohol in most effective suburbs, to develop stronger local alcohol policies, and to bring iwi and community voices to the table as part of long-term strategy to address the public health crisis. Auditor is prepared to work with council, health agencies, community providers, and to strengthen alcohol harm reduction strategies and create pathways to wellness. And in closing, we respectfully urge the committee to decline the renewal of the alcohol licence for 194 Bedford Street. And this is a critical opportunity to show leadership, uphold the spirit and purpose of the Act, and prioritise the well-being of a community that has long been overexposed to the impacts of alcohol. Ngā mihi ki a koutou. I can pass to my auntie if she has anything further to say or anything.
Yeah.
Ka pai, kia ora.
This is all very new to me. I currently work in the alcohol and addiction service. I've been there for 21 years, working with Auditor Mauri Ora. If we're looking at the alcohol-related harms, effects, including antisocial behaviour, which you know, domestic violence. It's also linked to 200 diseases and injuries, child abuse, neglect and poverty. So for every one person that walks through your door to buy alcohol, the other 6, because we're talking about Cannons Creek, which is Māori and Pacific, will be walking through the other social services door. Liz Kelly, the whānau centre, is probably taking all the kids during the holidays programs, providing them with something that they might never have had. Or food parcels, all our medical services that are up there, Auditor, Union Health and all the rest, all under the medical. They're taking the bulk of the families, which is the 7, and counting the 1 that actually is walking through your door to buy the alcohol. For us that works in the alcohol and addiction service, no sale of alcohol works for us. The harm is too great. Our role here with Auditor Mauri Ora and with the Runanga is to maintain mana mauri and tapu, Ours is health through the generations, hauora through the generations. There is no generational health with the alcohol that starts in. We're into whakapapa protection of our whenua as well. Our babies and tamarikis that go to school are all impacted just through that one person that walks into your door. I understand yours is about currency, money. Our currency is our well-being, our whakapapa protection, and our hauora. I don't know how you quantify that, but to us, that's what's more important than the money that you're collecting, than your currency. So, in regards to, the stats, that when it comes to Māori, we're top of the pops for all the wrong reasons. Our role here is to restore balance. That's what the health services try to do, is to restore the balance that harm has caused. So that's my kōrero. I thank you for that time. And so, yes, please, don't renew that licence.
Ngā mihi kia koutou. Any questions?
So I'm going to go to Ms. Burt first, the licensing inspector.
I have no questions, thank you.
I'll go to Dr. Palmer, the medical officer of health.
I have no questions, thank you.
Mr. Minimus, counsel for the applicant.
No, nothing from me either, thank you.
Any questions from the committee?
Sorry, I'm not on the mic. Dr. Liz Gordon, did you have any questions?
No, thank you, ma'am.
Okay, thank you.
I just have one question, Mrs. Stewart. You just said before that you're not solely in opposition, so you don't solely oppose. You're there to be a partner. What do you mean by that? Can you elaborate more on that?
Yes. So we do oppose this, as we've said in our statement. However, we want to work with. We are always looking to work in a space that is around working with our community to develop those pathways to health and wellness. We don't believe that the sale of alcohol, especially in small units, and in the manner that is being presented today, is working with our community and putting the community harm, and is actually proliferating community harm as well. Thank you so much.
Thank you for clarifying that. Okay, I will now invite the Medical Officer of Health to present any further evidence. I believe that you have one witness, being Mr. Speakman, because Mr. Tuputala isn't available today. Okay, so what we'll do is we'll ask the advisor to administer the oath or affirmation.
Dr. Palmer, as you're also giving evidence and so is Mr. Speakman, it might just be useful to take your oath now and then that's done and you can carry on in the order that you plan.
Affirmation. Yeah, I, Stephen Jeffrey Palmer, solemnly, sincerely and truthfully declare and affirm that the evidence I'm about to give touching the matters before this committee will be the truth, the whole truth, and nothing but the truth.
I, Chris Speakman, swear by Almighty God that the evidence I am about to give touching the matters before this committee will be the truth, the whole truth, and nothing but the truth.
So when Mr Marshall shares out the opening submission, I'll Right. Okay. May it please the committee, as Medical Officer Health for the Wellington Health District, I filed a report in opposition on 15 April 2024 pursuant of section 129 and 13 subsection 3 of the Act. I opposed the renewal of this grocery store on the following grounds. Section 1311D, the manner in which the applicant has sold, or the case may be, sold and supplied, displayed, advertised or promoted alcohol. The concern is that the volume of alcohol sold is greater than what would normally be expected. Also, section 131C, any matters dealt with in any report from the police, an inspector or a medical officer of health made by virtue of section 129, section 131A and section 1051A, granting this renewal will not be in harmony with the object of the Act. In that report, I raised concerns about the volume of alcohol sold. It appears to be high for a supermarket of this size, and single sales of alcohol, in particular high-strength beer. Also, there was concern about the close proximity to many sensitive sites. Mr Speakman will present evidence on these matters, in particular his conclusion that the single alcohol area is operating as if it is the single alcohol area for the Super Value store. Also in the report I alluded to the high deprivation of the Cannons Creek area and the high levels of alcohol-related harm. I'll present evidence on community risk factors and the high levels of alcohol harm. Regrettably, Mr Tuputala is now unable to attend the hearing. I feel that the evidence presented by the community objectors will cover what he was going to say. Also, I'd like to apply for a non-publication order. The address of Mr Tuputala is mentioned in paragraph 14 on page 148 of the bundle. Thank you. So I'll ask Mr Speakman to present his evidence.
Am I correct in saying it's taken as read? I'm
Yes, thank you.
quite happy to just take questions.
I just wonder if you could move to those two photographs of the store, Mr Speakman, and I don't know if I don't recall that in your evidence that you've gone into detail, 132 I think it is. There's 132
There's
and
two,
138.
there's 132 and 138. Two photographs taken as
So
my general impression of the store. I think we've been asked questions about these before.
So, can your purpose for taking those photographs, can you explain that to the committee?
Just to give you a general impression of what the store looked like to me as I entered.
So both photographs,
Sorry, can I just for the sake of the committee and everybody here, we're looking at the original bundle and we're looking at page 132 and 138. Great.
so you endeavoured to demonstrate the whole of the inside of the store with those photographs?
I tried to give an impression of what the store looked like, yes, correct.
So do any of the photographs have fresh produce in it?
The impression immediately is that there's a lot of lollies, sweets, fizzy drinks, etc., as you immediately enter that store.
Thank you.
Okay, so you're quite happy to take questions now?
I am, thank you,
Mr.
yes.
Smickman? Okay, so we'll start with Ms. Bird.
I have no questions, thank you.
We'll now go to the Te Rūnanga o tō rangatira.
We have no questions, thank you.
Mr. Middlemiss?
Did you want to go to Ms. Gordon?
Yes, sorry, Dr. Gordon, I'll go to you first.
No questions, thank you.
Mr. Minimus.
Thank you. Mr. Speakman, just wanted to refer to paragraph 26 of your brief, which I'm just going to find now. Yes, so it's on page 128 of the bundle. This refers to your engagement, doing a visit with Nicholas MacDonald, and you met with Neeraj, and during that visit you thanked Neeraj for his quick movement on the pricing for the high-strength beer and ciders. So just wanted to confirm that you have had positive engagement with the applicant on some matters.
Yes, I have, yes.
And those photos, you've just given evidence now that the purpose of those photos was to show the general impression, your general impression of the store when you walked in.
Correct.
So they're not an impression of the totality of the store, just of when you walk in.
They attempted to give an impression of what the store looked like, yes.
Right, but you accept that those photos can only show so much and that there's a lot more store than is shown in the photos?
You can't see the very depths of the store, no.
And you'd accept that there's no requirement to have your fresh produce or grocery items at the front of a grocery store?
You can have them where you like, I guess.
Yeah.
Yes.
So it's possible that, there's evidence that there is a lot of grocery products available for sale, but specifically in relation to this fresh produce issue, it is possible that the fresh produce is there in that store on the day you took the photo.
Maybe so. I did not see fresh produce on those days.
The evidence...
And walking around the store, there were other items there, but they were quite low in number.
The evidence from Mr. Patel is that there's been for quite a long time a range of fresh produce which has increased. Do you accept that evidence?
It's not my observation.
Now, in relation to the evidence of litter that you've found, do you accept it's possible that not all of that litter that you found came from the superette?
Possible, unlikely.
There are supermarkets nearby, correct?
Quite a long way away in
And other,
relation.
Right, and other bottle stores?
I'm not aware of any close by.
Not necessarily close by, but that's the beauty of the off-licence is that you can buy and take away, right?
Sure.
So is it not possible, especially taking into account the fact that the volumes of sale from bottle stores and from supermarkets are likely to be far higher than the superette, is it not actually quite possible that the litter has come from another premises?
It's more likely that people would buy alcohol from an off-licence to drink at home.
But is it not also possible that they could be buying alcohol to take home and then take it out to a park and drink it?
Possible.
Would the steps that the applicant has proposed to take around cleaning up litter outside the premises and willingness to introduce a more restrictive condition around single sales, would that go some way to resolving the concerns that you've raised?
I think the evidence of alcohol-related litter is not a matter of litter, it's a matter of people are drinking in the community, and that is the harm, not the litter itself. Cleaning up the litter may hide it, doesn't make it go away.
Right, but you've accepted that you can't directly attribute that litter that's found to the superette.
The products that I photographed are available for sale at Bedford Superette, which is much closer than any other premises in that area.
And they're also available for sale in almost every bottle store and in supermarkets?
They are.
Right. In relation to the condition around single sales, would that go some way to resolving concerns about people drinking alcohol in the vicinity of the shop?
The single sales condition is important to control the sale of the consumption of alcohol immediately, and it would help, yes.
There's also evidence around a willingness to increase the monitoring of that outside area and to involve the authorities more when drinking outside is witnessed. Would that also go some way to resolving your concerns?
I think that pushes the responsibility a little bit further away, and the immediate sale is the issue that's involved here.
What about if the applicant were to warn the customers? In fact, they already do warn them not to drink in the alcohol area. There was evidence from Mr. Patel on that. But if they were then to consider trespassing customers who don't heed their warning, would that resolve your concerns?
They would then be unlikely to be able to purchase the alcohol, but will it stop them drinking in the area? The applicant has already said they can't do that.
That's right. So there is only so much that the applicant can do, but would that step be a step in the right direction from your point of view?
It would show some responsibility from the applicant, yes.
Yeah, thank you.
I'll come to the committee for any questions.
Mr. Speakman, I think I just have one question. In your brief of evidence, you have referred to the Bedford Superette operating similarly to how you would expect a single alcohol area for a supermarket the size of SuperValue, particularly in size and volume of product available. That's paragraph 50 of your brief of evidence. And I just wanted to clarify, in terms of the, because what you're saying is the high volume of alcohol proportion is at a level you expect for a larger shop. And so is that relative to the size of the premises? Is that what you mean there?
Yes, I've been in quite a few dairies that sell alcohol, grocery stores that sell alcohol, pardon. These usually have quite a low volume and the turnover is not very high. Often I come across product that is past due by dates, for instance. In this case, the volume seems to be quite high. There's photos in here that I've taken fairly closely together, and they have quite different product available on the shelves. So there's quite a volume of turnover. I've made an observation that there's not a lot on the shelves, and the next time they're full, for instance. So it appears to be turning over very quickly.
Okay, thank you. That was my only question.
And I don't have any questions either, so thank you very much.
Can I re-examine?
Yes, go for it.
Thank you. Mr. Speakman, in your experience, the litter that you found would indicate that alcohol is being consumed in public. Is that correct?
Sorry, Dr. Palmer, can we make sure that we're talking into, because Ms. Gordon is
Let's repeat
online
that,
and she needs to be able to hear.
Mr. Speakman, in your experience, the alcohol-related litter that you found would indicate that there is significant drinking in public spaces further away. Is that correct?
I would make that inference from it. Also, the litter that I photographed was quite fresh. I have photographed alcohol litter in other areas, which appears to have been there for a long time. This is quite new. The labels have changed recently. For instance, the DB Export has different label now, and it's the label that's currently available that I photographed. So it's recent litter, and it's in public.
So, Mr. Speakman, in your vast experience of having covered off grocery stores, store licences in the Greater Wellington region, have you ever come across in any other grocery store people drinking just outside the store?
No, I haven't.
So you would say that's incredibly unusual?
It's
Yes or no?
it's very unusual.
Mr. Minimus suggested sort of things that the applicant could do. We met with the applicant back last year. Would you expect them to have already put in place those sorts of suggestions that Mr. Minimus has suggested?
Yes, I would expect that.
No more questions, thank you.
What we might do now is that we might just have a quick break for morning tea before we come to the inspector, and so that committee can have a talk about the new evidence that has been brought to us. So what we'll do is we'll go now, we'll be back at 10:20. Please help yourself to tea, coffee, Milo through in the tow ballroom. See you soon. Gordon, just making sure you're back here on board with us.
I'm here, ma'am.
Fantastic. Before we go to Dr. Palmer's brief of evidence, I am just going to pass on to my colleague to address some ancillary issues.
Thank you. So we've just in the morning tea break discussed the request concerning the further information that Mrs. Kelly has to give, and it is relevant information, so we will hear it. But we also are mindful that the applicant should have a proper opportunity to respond to any of it. So we've you already would have had a copy of the written statement that has been provided. And so, Mr. Middlemass, if there's anything that comes through the information that you think you need further time to reply to, then let us know and we can find a way of accommodating that. I also do appreciate that there was potentially some new information given in the evidence that was provided by Te Runganga or Tō Rangatira, and so same again, if there's any thing further that you wanted to add, please let the committee know and we can accommodate that where we can. So that's just the new evidence response to that, Mr. Middlemass?
No, that sounds appropriate.
Okay. Thank you. And then there's also been a request for a publication order concerning an address, and yes, certainly that will be granted. And I also wondered, in relation to the applicant, I do appreciate that there's been some sensitive sales information and whether there was a requirement for a non-publication order for that too.
I was going to make that request as well, yes, just in relation to the sales revenue information.
Okay,
Yes.
okay. Thank you. And one further thing, I appreciate that Mr. Tuputala is not going to be available at the hearing to give his evidence or confirm it or take questions on it. And I wondered whether the applicant had any objection to any of the content in that evidence that was given by Mr. Tuputala.
No concerns about that, just that it would be a matter of waiting for the DLC if he's not here to have his evidence tested.
Okay, thank you. All right. Thank you, and those were all of those ancillary matters.
Excuse me, Madam Chair. Can you hear me?
We can hear you, yes.
In relation to Ms. Kelly's additional evidence, she has also had and sent through to the Secretary a list of the alcohol-related incident reports from the whānau centre for the past 3 months. So these are incidents that triggered health and safety reports. There are 4 of them on the list. And she is wondering whether this can also be tabled in relation to her additional evidence.
Thank you. Sorry, I forgot to mention, yes, we have that. We have the statement, we have that. And the plan is to, after the medical officer of health has finished with giving their evidence, is to come back to Mrs. Kelly and cover this new evidence, and that will give an opportunity for parties to ask any questions that may come out of that, and then to go to the inspector as the final party providing information, and then we can discuss what happens after that. So that's the planned approach this morning. Thank you.
And with that, these handouts that you were given, the addendum is Exhibit H. Okay, so if I refer to Exhibit H. Palmer, going back to you.
Thank you. First of all, I'd like to take you to page 100 of the bundle, where I've put the matters in opposition. That's incorrect. I didn't have our final report with me when I prepared this brief evidence, but the correct matters in opposition are in my opening submission. So I'd like to take you to the attachments and go through those because they're quite technical, and any questions as we go through to just ensure that that's covered off. So.
Sorry, Dr. Palmer, so just to confirm, Exhibit G that was given to us this morning, this is what you're referring to?
The opening submission.
Yes.
Yes,
Yes.
that's got the correct grounds in it.
Okay.
Yes.
Okay.
Yes. I apologise for getting it wrong. I think if we go to 110 of the bundle, is that when we're trying to match up the health statistics, which we'll come to later on, the stats, New Zealand have gone way ahead of the health sector in terms of for the 2018 census, that they changed the boundaries and the way they looked at things. Like in the 2013 census, they used census area units, which matched the domicile code areas that are used in health. But in 2018, and then again for the 2023, they have used sort of statistical area ones, which combined together to statistical area twos, and the statistical area twos are almost the same as the census area units, but here in Porirua, some of the boundaries are quite different, and so when we look at the information from the censuses, they don't quite match up with the health information. So if we, Bedford Superette sits within Cannons Creek North SA2 area, and then you've got Cannons Creek South just below it, and then Cannons Creek East. And for the 2023 census, they split into the Waitangi-Rua into two SA2 areas, Waitangi-Rua Korina and Waitangi-Rua Tarangi. So if we go to page 111, these three SA2 areas are very, very unusual SA2 areas for New Zealand. There may be one or two SA2 areas in South Auckland that may have similar, but basically, if you look at the old Capital Coast District Health Board area, virtually all the Pacific peoples actually live in these three SA2 areas. So that's what's shown there in 111. So incredibly unusual demographic for, and I think in my brief of evidence, it's just over 50% of the population for these three SA2 areas are Pacifica, and I think it's down to 16% for Maori. So that they are incredibly unusual areas, and that needs to be taken on board in terms of understanding the vulnerability of the community. And I think it reflects on how the public spaces are used in particularly the Cannons Creek shopping centre area. Also, those three areas are quite different to New Zealand in terms of its demography, and that if you look at the on page 112, the age and gender pyramids, is that the population in these three areas is different from the overall population for Porirua and for New Zealand is that they're a much younger population. And I think, hearing the evidence and Mr. Speakman's evidence around his observations of how young people actually pass through this shopping centre reflects the skew towards the younger age groups in those three. So this just adds up to the vulnerability. And then on page 113, we have the deprivation indexes from the 2023 census. And if you look at virtually all the SA1 areas within those three SA2 areas is that it's in the 10th decile, which is the most deprived. And so this is one of the most deprived areas in New Zealand. There may be one or two in Auckland that may fit this, but this is really quite unusual. And this is, an indicator of extreme vulnerability. Like it's been picked up by Arla, like with the Fantame liquor store, the case law, and we've heard about this notion of increased suitability. This is the area that kicked that case law off, is that hearing for niches has now flowed through to even the Supreme Court, but that was pretty groundbreaking. So that this Cannons Creek community has had already a huge impact on the case law for New Zealand. If I just move over to page 114 and 115, this is just to really sort of, at the national level, alcohol is the most serious drug in New Zealand. It's a way ahead of, like, we hear lots about methamphetamine and that, but alcohol is the most serious drug causing harm in New Zealand. So, in my brief evidence, although we used to look at the emergency department attendances because that was all that we had, it's not helpful for Porirua in that many of the those that would normally attend emergency departments attend the general practice A&M service at Kenaparu. So I haven't really looked at the emergency department attendances because they will be low for Porirua, but I have looked at the the alcohol-related hospital admissions, which are probably more robust than the emergency department attendances. And so, unfortunately, in the hospital databases, they don't have an alcohol flag for each patient, but they do have, there's a list of everybody that is admitted to hospital is given one or more diagnostic codes. That's called the International ICD, and we use the same version as used in Australia. So there's a list of ICD codes that are 100% due to alcohol, and they're listed on page 116. So, and they can be broken down into acute conditions and chronic conditions. And the chronic, as I'll show later on, is one of the key things that I've found with regard to this local community. So basically, it's quite obvious, like they're all sort of called alcohol-related conditions and acute intoxication and alcohol poisoning. However, there are a number of conditions that where alcohol is one of the contributing factors. And so those codes are listed on page 117. And last year, the fractions for those were published for New Zealand. And so, and the fractions are sort of broken up by 5-year age groups and whether they're Māori or non-Māori. I put the average there. So if we look at sort of something like assault there, is that on page 117, 13% of all assaults that are admitted to hospital are linked to alcohol. And so we can look at applying that. They're called alcohol attributable fractions. And so, but also what's useful to look at is that there's both acute. So basically the acute partially attributable are all the injuries that are admitted to hospital that are linked to alcohol. And so you can't do that by, say if somebody falls over, which is quite and sustains a head injury, so the principal diagnosis will be head injury, but the causal factor will be fall. And so you've got the causal factors for all the acute partially attributable when you look at them, they're all sort of injuries, which is quite important. But then on the chronic side, like, for example, the most common cancer linked to alcohol is breast cancer. But alcohol is only one of the contributing factors to that. So if we go to page 118, you'll see breast cancer there, and on average, 16% of all breast cancers are linked to alcohol. And so is there any questions on that? That's quite a complicated thing to...
When you say linked to alcohol, is that meaning that it's one of the contributing factors? 16% of breast cancers have a contributing factor linked to alcohol, is
Yes,
that?
yes,
Okay.
yes. So when they calculate the alcohol attributed fractions, and it actually began with WHO doing this about 10 years ago, and they're published on a regular basis by the stats, equivalent to Stats New Zealand and England. So when they calculate those, they take in, there's a method of doing it, and they take into account the alcohol consumption as well. So they're quite different to the Australian alcohol attributed fractions I used to use. Some have gone up and some have gone down. But yeah, it's practically the only way of dealing with these is to calculate the alcohol attributable fractions, and it's a standard sort of process sort of throughout many countries. Unfortunately, we didn't have the New Zealand ones until last year. Yeah. So, any other questions?
Some pretty scary figures in there. But is the only answer, are you suggesting that the only answer is not just to neglect or reject this licence, but all alcohol?
No, I think sort of it is different for different areas. And when I go through the next ones, like the levels here, particularly for these sort of Cannons Creek and Waitangi are pretty high when compared to the rest of New Zealand. They're not up with, say, central Wellington, which is extraordinary, but they're high, very high for a normal residential area. And although my colleague over there talks about the general. In fact, if you look at the Lion Retail case, which I took with regard to Liquor King in Wellington, as the High Court judge there said, where you've got very high levels of alcohol-related harm, of course an outlet is contributing to that. It's just common sense. So if we go, sorry, have I answered your question? Yeah. So,
Sorry, can I just make an observation in terms of process? I do appreciate that we are asking some questions at the moment, and this is just limited to some of this technical information, just to so the committee can understand this. But there will definitely be an opportunity, as usual, for all parties to ask any questions they have of Dr. Palmer.
Absolutely.
Just to highlight that. Thank you.
Yeah. So on page 119 this is the map of the domicile code areas that are used by the health services. So every patient now, right from birth, is given there's a National Health Index number, and connected to that is the address and the domicile code areas. So in the national collections, they don't have the actual address because it'd be possible to identify people. So so this map is of the domicile boundaries for the domicile areas, and you'll see that Waitangirua is not split as is for the 2023 census, but the other boundaries are not quite the same as the SA2 areas. So, as I said before, in relation to page 119, is that the domicile code areas mapped to the area units used in the 2013 census. I'm not quite sure when the Ministry of Health is going to update things, but they certainly haven't kept up with the Stats New Zealand and how. So on page 120, there's a map of the wholly acute alcohol-related admissions to hospital. Now, up to 60% of these will be for acute intoxication, where the patient actually gets admitted, like everybody that spends more than 3 hours in a hospital, whether it's just in the emergency department or not, is concluded as a hospital admission. And so many of the acute intoxication admissions are for really observation overnight. So they stay on the ward attached to the emergency department, and they are every patient is mapped to a specialty, and they're mapped to the emergency medicine specialty. So we can see the height of the polygons here is the actual number, and the colour is, I've compared the domicile code areas here in Porirua to all other domicile code areas in the country, and I've split them into deciles. And so if you look for Cannons Creek North, which is red, that's where the store is located, is in the top 10% of domicile care areas in the country. And the other two, Cannon Street East and Waitangirua, are in the top 20% of these, and this is really sort of, a large proportion, as I said, of these are for acute intoxication or acute poisoning. So I think that's pretty significant in terms of, this is not general information, this is very specific information, and it's inevitable that Bedford Superette will be contributing to these high numbers. If we go over to page 121, so is there any questions about that first, just for clarity? Okay, so if we go over to page 121, this is for the partially acute related emissions, and this is for injury, as I said before. And so we can see that Cannons Creek North is in the top 20% of domicile code areas in the country for emissions for injury, and that the Cannons Creek East and Waitangi River sort of fall back to being in the top 20% of domicile code. So it's not quite as high as the wholly acute, but it's still pretty high when you compare it to the rest of the country. And for attachment 13, and I was quite shocked when I undertook this analysis, is that this is for, I combined the acute and chronic, wholly and partially attributable together, and yes, extraordinary high for, particularly for Waitangi Rua. It's in the top 10% for chronic conditions, and Cannons Creek North and Cannons Creek East, and is in the top 20% for the country. But these, I think these are quite extraordinary figures. I forgot to mention that Waitangi Rua South is grey because it's just to calculate, and I forgot to mention that the colours are linked to the standardised rates. So to compare apples with apples, like when we had the age and gender demography, is that different ages have different rates of alcohol-related harm, and so to compare apples with apples, instead of doing just an overall rate, you actually do a standardised rate based on the World Health Organization standard population. So when I say that Waitangi Rua is in the top 10%, that's for rates rather than numbers. So Cannons Creek South doesn't have a big enough population to calculate a rate, is that whatever figure you're going to get will be potentially quite extreme. So the populations, and there's a cut-off point in populations for calculating age standardised rates, but the height is the level. So I think this is quite extraordinary, and I put it up against the evidence we've heard about public drinking and what is actually going on, particularly in that Cannons Creek North area. And finally, on page 123, I looked at the trends over the monthly trends, which in this graph, the actual numbers are the blue line for each quarter. I've used a statistical package developed by Facebook to look at the seasonal variation by quarter, and so the red line is the smoothing of those, and the grey area is the 95% confidence interval. But when I looked at all the different ways you could look at it, and there's been already a drop in the number of off licences here in Cannons Creek, because I believe the store next door to Bedford Super, before it changed hands, did have a liquor licence, but the new owner decided not to have it. So we haven't seen a decrease yet. And in fact, in in men aged 45 to 64 years, there's actually an upward trend there, but for all the other ways of looking at it, it's fluctuated, but it's stayed about the same. So what I'm hoping is that we will, if you decide to decline the renewal, then I'm hoping that we'll start seeing a downward trend. Thank you. I'm open to questions, and that's.
Thank you, Dr. Palmer. I'll go to Ms. Burt first.
I have no questions, thank you.
Mr. Stewart, Ms. Metiking.
No questions from us, thank you.
Dr. Gordon.
No, thank you, ma'am, and thank the medical officer for his evidence.
Mr. Middles.
Thank you. Yes, Dr. Palmer. Just wanted to clarify your evidence at paragraph 53, brief, which is on page 108 of the bundle. Just in that paragraph, I'll just quote it. You say, also, Mr. Speakman presents photographs of the extensive alcohol-related litter he found in the local environment. This could only have come from Bedford Superette. Now, I just want you to confirm that it is possible that that litter has come from elsewhere.
I think Mr. Speakman has answered that, but, you know, when you think about it, if people are going to go buy from supermarkets a long way off, they're more likely going to be taking that home to drink rather than deciding to go out into the public spaces.
But it's entirely possible that someone went out for a picnic or an event and took alcohol from home for that purpose.
I'd suggest that that's extremely unlikely.
Extremely unlikely that people might take alcohol to a park for a picnic or an event.
I think that yeah.
Would you say that spirits and RTDs are high risk products from an alcohol-related harm perspective?
I think RTDs where they're available, but you know, I think wine in particular and beer are the really common drinks. Like for this community, given the deprivation, I'd question whether they could afford spirits.
The evidence that you've got of alcohol-related harm in the community, it's very possible that a chunk of that is a result of spirits and RTDs.
Yeah, I'm not suggesting that the levels there are wholly due to Bedford Superette, but what I'm saying is that Bedford Superette is one of the contributors to that.
And it's not possible to determine to what extent that the Superette has contributed to that.
No, it's not possible.
And just to talk about the scale of the alcohol-related harm, of the specific evidence we have, I'm just going to make the point that when I'm talking about specific evidence, I'm talking about evidence that specifically relates to the Superette, not that your evidence is not specific, because it is exact, it's well researched.
Yeah.
That's the point I'm making there. So the specific evidence we have heard from the witnesses is that people are drinking outside the premises, drinking alcohol outside the premises, and that there is litter being found outside the premises and further afield. Is that correct?
That's what we heard yesterday.
Yeah. And the evidence of Miss Hannafin was that those people that she saw and took photos of were peacefully drinking, albeit in an alcohol ban area.
Yes.
Yeah. And so Miss Hannafin and Mr. Speakman have given evidence of the alcohol-related litter, which is evidence that people are drinking alcohol outside and likely drinking in public places in other parts of the community. Now, is it not that, wouldn't you say that that's less serious type of alcohol-related harm relative to other types that you...
I'm glad you said that people drinking outside is a form of alcohol-related harm, because that fits in with the definition in section 4 of the the Act is that people drinking outside is, in fact, in terms of Section 4, evidence of alcohol-related harm.
Yeah, I just think it's important to place the level of harm that we're talking about because, you know, there's other types of harm from alcohol, which drink driving causing injury or death, fighting and disorderly conduct on licensed premises, in bars and things.
So if they're admitted to hospital, they would be in those stats, particularly on page... So assaults would be included in
That's
page 121.
Not disputing that. I think the question is really, we don't have any specific evidence of, let's say, drink driving causing death. On this date, so-and-so consumed alcohol from Bedford Superette and then drove and caused an injury or death.
Okay, so that brings me back to the Lion Retail case where the Wellington City DLC decided to reduce the hours on Friday and Saturday night, and Lion Retail appealed that to Ala, and Ala said we couldn't link those stats to that specific premise, but I appealed that to the High Court, and the High Court.
I just realised you might not have been here for my opening submissions where we've already laid all of that out and agree that where there's alcohol-related harm in the community and a premises is implicated, then that the DLC is entitled to act and to impose restrictions to including the precautionary principle.
So I think,
no dispute there.
Yeah, I think if the three maps there sort of had all the domicile code areas sort of in the light green or yellow, I think that argument applies. But when you have extraordinary high levels of alcohol-related harm, and I'm not suggesting that the Bedford Superette is the sole source of alcohol for this, but it will be a contributing factor.
That's right. And just to go back to that question on the scale of harm, you would accept that the levels of harm that we are seeing specific evidence about are less serious than other types of alcohol-related harm?
No, this is only the tip of the iceberg. You know, there'll be, like, I think drinking outside is an example of a lower level of alcohol-related harm, but it's still alcohol-related harm. So there's a lot of alcohol-related harm that won't be admitted to hospital or attend the ED or the A&M. And so this is the most extreme forms of alcohol-related harm. There'll be considerably more alcohol-related harm in that community that we don't have any statistics.
That's right, and we don't have any evidence about that other harm that's going on, other than your evidence. No, you know, of that you provided earlier today. We don't have any specific stories about harm occurring in the community.
Well, I think you've got specific stories about in terms of the drinking outside.
Oh, yes. No, that's taken.
So that's a pretty specific story to my mind.
Yep, agreed.
Yeah.
That's what I'm saying. The specific evidence we have is on relation to drinking outside and litter, but the evidence that you're talking about is more general and more serious, probably alcohol-related harm occurring in the community generally. I'm just saying that we don't have any specific evidence that shows more serious types of alcohol-related harm have occurred in and around or because of the superette itself, specifically the superette.
I think you have, because you know, like these communities are at a very high level of deprivation. It's questionable whether they may not have a motor vehicle to go to, like the supermarkets are some distance away from. So from a convenience point of view, they're going to go to the closest, and Bedford Superette will be in walking distance of most of the residents in those in Cannons Creek.
Well, all I'm saying is that there's no actual specific evidence of, let's say, for instance, domestic violence going on from somebody having consumed alcohol from the superette. Like, that's what I'm saying. It's like
unfortunately the police didn't.
That's right. That's the point I was going to make to you.
Yeah, and it's unfortunate that the police didn't get involved in the recent exercise of infringing.
If there had been criminal concerns occurring in and around the premises, would you not expect the police to raise those in some way in a report?
Yes.
Yeah. So you'd accept also that there's no significant adverse evidence about our client's suitability in terms of dishonesty or breaches of the Act, other than maybe this argument around Condition F, which I'll make submissions on, but we haven't had any other significant adverse evidence about suitability.
When I reflected on yesterday last night, I thought that Mr. Patel's evidence was quite arrogant, and I think doesn't fit in with the notion of increased suitability. I think we've had evidence already in this room around the suitability.
But we've also had evidence that the applicant has, and in fact from yourself and Mr. Speakman, that the applicant has engaged with the authorities in an attempt to resolve concerns, to some extent.
To some extent, I would have expected them to move a lot more than what they have done. I would have expected, particularly in the May photographs that Mr. Speakman took, I would have expected to see a lot more groceries and fresh produce in that photograph. Like Mr. Speakman, the purpose of taking those photographs was to demonstrate that there wasn't groceries or fresh produce there in the shop when he visited for that photograph.
But Mr. Speakman has accepted that it was possible that there was food or fresh produce somewhere else in the store. That was his impression of the store upon his entrance. Is that right?
Yes.
Yeah. Right. Nothing further from me. Thank you.
Does the committee have any questions for Dr. Palmer?
Yes. Dr. Palmer, in your brief of evidence at paragraph 50, which is on page 107, you've said that although the number of alcohol outlets in Cannons Creek have stopped selling alcohol, the levels of alcohol-related harm have remained very much unchanged. And you've also earlier just talked more about the change in the community and the hope that if a licence for this applicant is denied, that may improve. But in terms of what's already happened, there has been, according to your brief, a number of outlets that have already stopped. Yeah. And there doesn't seem to be a correlation with that to the statistics that you are seeing. And in terms of the link between the alcohol that's being sold and it being linked to alcohol-related harm in the area, I mean, is there, if so far there hasn't been shown any difference, what is your view on whether this might have any, this applicant, if it isn't no longer selling alcohol, what might the impact be?
Well, I think that it's the convenience of the Bedford Superette being in close proximity to residential areas and really within walking distance for those is that it's really that Bedford Superette really enables the how can I put it, the easy availability of alcohol, and I think sort of the drinking outside actually confirms that, is that I suspect that most of those people drinking outside will have walked there because it is convenient. We have the liquor stores over in Waitangi, Big Barrel. There's nobody drinking outside those stores, even though there's a playground there for the Big Barrel. And it's incredibly, as Mr. Speakman said, we've never come across this at all. And like, we've been looking at grocery stores and supermarkets since the new Act came in 2012. And we've never come across the likes of that. And when you look at the evidence that was presented at the super value hearing, and that included Miss Kelly, and that none of them presented evidence on drinking in public spaces there. So this is a new thing. When I learnt about it, I was absolutely horrified that this is extraordinary, the level of harm that indicates.
Thank you. In terms of tying that to the object of the Act, which you've mentioned in section 4, and that talks about the sale and supply and consumption of alcohol being undertaken safely and responsible and minimising harm, not outruling harm, but minimising it. And then it has a list of what is included as harm caused by excessive and inappropriate consumption of alcohol, and also harm to society generally. So in terms of the drinking outside that's been identified, where do you think, Dr. Palmer, that would fit within the object of the Act and the alcohol-related harm that's talked about in section 4?
So drinking outside, firstly, is a crime because it's a liquor ban area.
Okay.
Drinking outside is a form of disorderly behaviour, and that drinking outside is causing extreme harm to that community, particularly to the young people.
Okay.
So, as you know, the definition is incredibly broad, and it's both sort of even both section 4, subsection 2, and both A and B are there when you really think about it. And as I said before, this is extraordinary, and I think if we had known this at the time when we met, I would have been beating the table. But I've only become aware of this with the I think it was Miss Hannafin's initial photograph, which I didn't see, but I heard about it. And then, I'm absolutely, in a way, devastated that I've allowed that to happen. We didn't oppose last time because we were involved in the super value hearing. And I get the impression that this is a very recent occurrence, and I suspect that is that with Mr. Patel, it's probably got worse. Like, I was horrified to hear what he said yesterday. If I was a good licensee, a suitable licensee, I would be out there and kicking them off. And if you knew who they were, I would not be selling to them, because that's just dreadful, in my view. I've not come across that before.
Thank you. Just in terms of recent changes or trends, you've mentioned that in Waitangiroa there's nobody drinking outside, and I just wondered, when was the last time you had an opportunity to have a look at what's happening in Waitangiroa?
Well, those two licences have been up for renewal in recent times, and it'll be Mr. Speakman and his colleagues who will assess those, and they have not reported back to me that they've observed any people drinking outside. And I would, if they had observed that, I'd expect them to report that to me. Yeah.
Thank you. I have no further questions.
Just on that last point, I drive past the bottle stores regularly, and you're right, the Waitangiroa ones don't seem to have people outside. But have you ever visited the Titahi Bay shopping centre?
once again, they come up for renewal, and I have visited them, but some time ago. But I expect Mr. Speakman or his colleagues to, like, this is a really serious breach of licences actually having, even if you have an on-licence, somebody is drinking outside, that's a very serious. We do have occasional problems where people drink in cars in the car park of on licences, but a grocery store, it's extraordinary.
Okay, well, I've got some other questions, and we're going to leave aside whether it's a grocery store or a convenience store, because I think we're going to do a site visit ourselves to hear what's happening. And given that this is a vulnerable community, always has been, because that's where I started off from my state house 70 years ago.
I did visit the top town back in the 1990s.
Okay.
Which
well, we've also heard from people who are trying to alleviate some of the problems, some of the submitters. But if the licensee was able to meet some of the conditions, or like stopping the drinking outside, which I think is also a police problem because it is, as you say, illegal. If they were able to give us some suggestions, or if, and again, the litter might be a council problem as much as it is to any of the retailers up there. If they were able to meet those, and one about the confusing, contradictory wording of bottle sales, single bottle sales, all those sorts of things, if we addressed all those, and being that it's an existing licence, should Cannons Creek people be able to enjoy the guilty pleasures of other New Zealanders locally, even though it's an area of low incomes, and the problems that come from low incomes?
Yeah, I have no sense that they will actually adequately implement those extra measures. I think they could have done that already. So I have no confidence in the applicant, and particularly after hearing Mr. Patel yesterday, I have absolutely no confidence that they'll do what they say they're doing. Like, in terms of the social responsibility policy, it was clear that there should be no people drinking outside, and they haven't even implemented that. And I think Mohammed, sort of many licensees, when there's opposition like this, will then see the need to pull their socks up, even after meeting with us. And when they responded, it was just so little. So I don't think we can contemplate that we have confidence that they'll do anything more than what they're doing now.
Thank you. So, well, just to follow up on that, so prohibition's the only answer?
I think that this is the wrong site to have an alcohol outlet like this. If it was run as a normal dairy, which basically it is a dairy, or a convenience store, and not selling, I think this is an incredibly unusual area in New Zealand because of the vulnerability and the need. There's a lot of social services and treatment services there in that community, because that community is already suffering, and so the presence of an alcohol outlet, I think, and those sensitive sites that were mentioned yesterday, which it's an extraordinary cluster of sensitive sites. I don't think there will be anywhere else in New Zealand quite like that, because there's nowhere else in New Zealand that's quite like Cannons Creek. And so it is an alcohol outlet, and that isn't in sync with how people use the shopping centre there. So I just think it's just the wrong place to have it. And I think the people of Cannons Creek have more than adequate access to liquor stores in Waitangi and I think the closest supermarket is Aotea Woolworths. So they don't really need an alcohol outlet like this.
Okay, thank you.
Thank you, Dr. Palmer. Just picking up on your last, you said that Cannons Creek is a very unique community, and I agree. I was born and bred in Cannons Creek. You say it's a unique community and there's no need for a site there because they can go to supermarkets in Waitangi. So would it still not be a problem, even if there was no license to be, if there was no license, would it still not be a problem if they were still able to access it somewhere else close by?
I don't know if I can answer that. You probably, having lived in the community, probably, like, there are going to be some that will have the ability, have a car to drive to that, but the fact that the convenience of the availability with Bedford Superette is that there are going to be some that won't go and purchase alcohol from those areas.
Thank you. Just come to your last point in your brief of evidence, just to about applying for the non-publication order, and we will certainly grant that. That's fine.
Yes.
Great.
Thank you.
Thank you, Medical Officer of Health. We are now going to go to Mrs. Kelly. As explained before, we've been given Exhibit H in regards to an addendum to the first witness statement of Liz Kelly. We also will give everybody the opportunity to ask Mrs. Kelly questions when she is finished. Please go ahead.
Thank you, Madam Chair, and thank you for this opportunity. It wasn't until some of my kaimahi were in the gallery and they reminded me of a couple of incidents, and it was a long day yesterday, and when I reflected on the question that was asked, I thought it was important to table this addendum. So essentially, when I was asked whether I've witnessed an increase in public drinking, I responded affirmatively, noting that I typically observe people either intoxicated or drinking in public at least twice a week. And I now include 2 recent incidents to support my evidence. I guess too, if I could just say, I'm not there at the whānau centre every day, all day, and yet I still witness this. And if you're going to do a site visit, you'll then understand where the whānau centre sits in relation to the superette. And so, while I don't witness the drinking outside the superette that's been tabled by a witness, I do witness what's happening at the back. And so I'm tabling this to give you an understanding that it is widespread. It's not just in front of the superette, it's in the area. So I remembered a few weeks a wahine had entered our premises through an unlocked back door and made herself comfortable while drinking from a can. And when she was spoken to, she initially left the building, but shortly afterwards caused a loud and disruptive altercation outside with rangatahi, returning home from school. Apparently she was known to them through their mother, and the situation escalated and the police were called due to her becoming violent. You'll see as well that I've also tabled our incident report, and that particular person it did escalate. She came back. The police were then involved again. And then I also remembered the incident, which it turns out it was in March. And it was in the weekend, and I received a call from security telling me that our smoke alarm had gone off in a certain area. So I went up to just check and to make sure everything was all right. And when I arrived, there was rubbish that was smouldering in the vacant section with all the debris that's still there from when the graffiti bar burnt down. And so we called the fire brigade to put it out. And then when we went and had a look at our cameras, we were able to see that it was problem drinkers that were known to us, and that they had also tried to set fire to the skip that was outside, which was full of rubbish, that was outside the Opportunity Centre, which has now been refurbished for time and Nino services. So the firemen put that out as well. They put a whole bunch of foam and everything in to make it impossible to reignite. And then the firemen called the police as well, and they called and wanted to see our footage. So those were just incidences. And then in our incident book, I've tabled that, so that's still H, for you to have a or question me or look at it or whatever. So thank you for the opportunity to expand on that question.
Thank you. I think I'll go with you, Dr. Gordon, first. If you have any questions for your client.
Ma'am, I have no questions, thank you.
Ms. Burt?
No questions, thank you.
Dr. Palmer?
Yes, I've got a couple of questions. Ms. Kelly, Mrs. Kelly. How long have you been running the whānau centre there in Cannons Creek?
15 or 16 years.
So, over that time, have you observed drinking in public?
Not to the level that it is now. And like you, I was actually shocked and went for a bit of a tiki tour to observe what our witness had presented.
So, at the time of the super value hearing, was there much drinking in public? Can you recall?
No, not to this level.
Yeah. Now, Mr. Middlemas has suggested that the alcohol-related litter that's in Mr. Speakman's evidence could have come from people that have gone and purchased alcohol from the supermarkets. What is, with your experience of living and working with people in Cannons Creek, what is your opinion on the validity of that argument?
I would say that it's fairly unlikely. And even the suggestion that it might have been bought somewhere else and they would come and have a picnic. Having a picnic in Cannons Creek.
So it's pretty uncommon. It's pretty uncommon to have a picnic in Cannons Creek.
Yes, and having said that, can I also say that while we have our troubles in Cannons Creek, the people who live in Cannons Creek are very proud to say that they are from Cannons Creek. So while I just don't want to sound like I'm making light of the area, because Cannons Creek is their home, and there's a lot of positivity that does come out of the creek, but unfortunately there is, because of being a low socioeconomic area attached to that, a lot of supports are required.
Thank you. No more questions.
Ms. Metikini?
No questions.
Mr. Minimus?
Yeah, thanks. Just a couple to clarify a couple of things. So am I right? The incident log date, the entry for 23 April 2025, the details say a PwC staff member observed the same woman. Is that the same woman as the 15 April incidents?
Yes.
Right. So 3 of these 4 incidents were the same person? Possibly 4, but definitely 3.
I'm assuming that 23 April is the same woman, because it says the same woman.
And other than the 15 April entries, so the 23 April and the 23 March entries don't refer to alcohol at all, do they?
No, but I witnessed the 23rd March one because I attended that as a call out and observed in the footage that they were drinking.
Okay, you didn't say that in your additional evidence, did you? You just said that they were problem drinkers.
That's how I knew they were problem drinkers.
Okay, nothing further from me.
Let's come to the committee.
I have no questions.
Have no questions. Thank you.
And I have no questions. Thank you, Mrs. Kelly.
Can I, though, just check, Mr Middlemass, is there anything further you wanted to add to address? Have you got some...
I'll just quickly speak with my client.
Okay.
I mean, my client does have another comment that he would like to make. Is he still under oath, or shall we do it again?
Firstly, I think it's fair that he does have an opportunity to reply, given that this is new evidence. And given that he's already been sworn in, I don't have any difficulty if he's not sworn in again. I mean, the same criteria applies. So I think he can give some further evidence. Of course, that will also be open to question from all parties as well. Thank you.
My understanding is it will be very brief.
Morning, everyone. Thank you. So just now I heard about the incidents happening in the car park or in the Licklebain area. The next door shop to Bedford Super 8, which is also another Super 8, has gone into a new ownership just a few weeks ago. And the new owner, yes, decided not to keep the alcohol, but the previous owner was selling alcohol. And possibly March or maybe end of April, there was previous owner who was selling alcohol. So there could be many reasons that the people have bought alcohol from that shop as well. And some other incidents might be related to that as well. Thank you.
Thank you for that as well. I think we're still yet to go to the licensing inspector, so that possibly could be a question for our licensing inspector in regards to the other off licence.
Can I just confirm the question that was asked of me about that being the same lady? I've been able to have that confirmed that it was the same lady, and essentially it's because there's a derelict building opposite us that was the graffiti bar, and she's known to be staying in there.
Okay, thank you for that additional information. Is there anything further you wanted to add, given that there's been some further information, or you're happy with what you've said?
Not related to the one which I just said. but there are some pictures from last year where it's showing the first visit from Mr. Speaksman when the pricing was very low, and we quickly resolved that. But last year, around October, my staff visited the next door superette, which was selling alcohol, and their pricing was also quite high, and they also had invoices where the liquor was sold, but it was shown something else in the invoice. But yes, not related to this one. Yeah, so sorry.
Thank you. And does any of the parties have questions for any of the information that has just been given? You do, Dr. Palmer?
Just when did the next door shop change hands?
I'm so sorry, Dr. Palmer. Dr. Gordon can't hear you online because you're talking away from the microphone.
Okay.
Thank you.
From your recollection, when did the shop next door change hands?
Don't know the exact date, but it happened almost 5 to 6 weeks ago, because before that I met the previous owner by myself in his shop, and now there's a new face, a new person running it.
So you say that the prices were high?
Under the previous ownership.
Yeah. And were they breaking, from your observations, were they breaking apart, or did they have any single sales?
Yes, they had single cans. And also, before that ownership changed, they had their license renewed as well. And they're just next door to this shop.
Yeah, I don't know. Okay, thank you. No more questions.
Thank you. Okay, so no one has any other further questions, so we can now move
Yes.
back to you.
Great. So I will now invite the Porirua City Council Licensing Inspector to present any further evidence, and we'll ask the advisor to administer the oath or affirmation.
Thank you. I, Joanne Heather Burt, swear by Almighty God that the evidence I'm about to give touching the matters before this committee will be the truth, the whole truth, and nothing but the truth. Thank you. Thank you. We're just trying to locate the exact date that the premises was taken over. We were advised that he was running out of stock, but the new owner had no interest whatsoever of obtaining an alcohol licence. So we were advised they were running stock down. We were asked if we were interested in buying the building, but we don't have an exact date when the new... Is that right? No, we don't have an exact date when the new operator took over, because alcohol wasn't being
We can address that a little bit later on.
Yeah, so that's perfectly fine. Thank you. Now, a couple of things in addition to my brief, which I'm assuming I can take as read. I have mentioned on my report and on my brief of evidence, page 90 of the bundle, I have made a bit of a faux pas. And it's page point 23. Oh, sorry, it's not 23. It's point 22 on page 89. I've said that the reverse sensitivity does not apply. Well, I've said it applies, but it should not apply, only to the fact that it's in my opinion that there has been a vast change in the nature of operation. To clarify that, yesterday I made mention to previous figures, and that was based from the previous renewal. And I do have copies of those figures. So people, because I did make mention of 55.5% and 2%. So I have copies of those figures that I'm happy to produce. They were from the previous application. There's 9 copies there. The other piece of paper I've got here as well, and I've also got 9 copies, when I was cross-examining witness yesterday, Kapik he referred to the host responsibility policy that was in the toolkit. I've actually taken a copy of that page that's in the toolkit for everyone. It's actually a sample host responsibility policy. It's actually not a host responsibility policy, and I produced that. There's 9 copies there. Thank you.
Thank you. So what we'll do is we will mark this one as Exhibit I, and then this next one as J. I've got that correct. I'm not going through the alphabet nearly at C.
Thank you. Now, also my colleague has just advised me that the off licence for the superette was actually surrendered on the 25th of October 2024, so no alcohol was sold from that site. Sorry.
Thank you.
At Warspite Ave, yeah. 4 Warspite, Cannons Creek Superette on October 2024.
Thank you for that.
Sorry, just to clarify, that's the shop that's next door?
Yes.
Thank you.
I think they were the only things that I just needed to. The other comment was with regards to Afterpay that I've made mention when I spoke at my inspection. Just to advise that I've had meetings with 2 other licensees in my time here as an inspector in the past year, and they have actually willingly removed the Afterpay function. And I appreciate that the applicant is prepared to remove that as well. The other thing is in my brief of evidence with regards to after my inspection, the manager on duty had not been appointed as a manager. It was last week that there was 2 emails received, 1 email sending a copy of the manager's certificate. He still hadn't been appointed as a manager for the premises. And the next day I received the correct form completed advising he was now the manager of Bedford rather than Thursday Liquor Waitangarua. But on saying that, I've received no terminations of managers' appointments at all. But they're the only additional information that I needed to clarify.
Right. Thank you, Ms. Burt. I am going to go to Dr. Palmer, the Medical Officer of Health, if you have any questions.
No, I have no questions. No, I don't have any questions.
Mrs. Metakingi?
No questions.
Dr. Gordon, do you have any questions?
No, I don't, thank you, ma'am.
Mr. Minimus, do you have any questions?
Yes, only a few. Yeah. Just in relation to the local alcohol policy matters, can you just confirm and evidence that you didn't raise that with the applicant at the time of application?
To be quite honest, I wasn't here at the time of application. It wasn't me. I've only been here since May last year. So no, I personally didn't, but we can ask my colleague.
You're not aware yourself whether that was raised with the applicant?
No, I'm not aware.
And the applicant's evidence was that it was not raised with them. So you probably can't say further than that.
No, sorry, I can't comment.
In terms of your comment in your brief, I've just lost your brief and I'm on it electronically. I've lost the page.
79.
79, thank you. There was a comment in there around the change of the business, the nature of the business in relation to the local alcohol policy point.
Yes.
Yeah, so you were just talking about it, right? In paragraph 22.
Yes.
Now, if we just refer to the actual clause in the LAP on that reverse sensitivity point, it says proximity to a sensitive site will not be considered for new licence applications for premises for which an existing licence is held at the date of the application, unless the nature of the application differs significantly from the current licence. This is to protect the pre-existing use rights in those premises. That's right?
That's correct.
So this is a grocery, well, this has previously been licensed as a grocery store and it is seeking a renewal of its license as a grocery store. I'd just put it to you that that's not a significant change of the current license.
I believe that the information that we have in front of us and the lack of clarification with regards to figures compared to the previous renewals figures is a significant change.
Right, but the application is for a grocery store renewal.
That's the only similarity, yes.
But that's a pretty big similarity. It's not trying to change its activity to a bottle store or to a bar. Wouldn't you agree with that?
I still believe the figures that we have obtained with the application differs.
Right, but that following sentence, that final sentence of that clause D, this is to protect the pre-existing use rights in those premises. So when we're talking about use, we're talking about an activity. The activity is grocery store or superette, and that's what we're trying to get a renewal for, right?
Right, yes.
Yeah. And in any event, I guess the variation to the application or to the conditions of the license, the sought variation is to reduce the single alcohol area, correct?
Correct.
And so the net effect of that variation would be to reduce the availability and visibility of alcohol, correct?
Correct.
And in relation to the wording of condition F, which was exhibit, I don't know actually which exhibit that was. Oh, B. I've got it written as exhibit B.
Yes.
Yep. Do you accept that the wording of that condition as it currently stands theoretically prevents the sale of wine from the store?
I'm not convinced. I was contemplating it last night, and I spoke to a friend of mine in the industry, because when alcohol is ordered through a supplier, it's actually ordered by the number of bottles. How it comes in a box, probably convenient-wise, but it's actually ordered by number of bottles, which I don't believe that it comes in, we could say it's a pack of 12, because it's actually purchased or ordered through number of bottles. Right. I totally understand what you're saying. I agree that it's not a well-worded condition, but I don't agree with the bottles of wine situation.
Right, but in this, if we were to take this condition literally, the applicant would have to order individual cans of beer, of 500ml cans of beer, in individual units in order to sell them as individual units?
They would, yes, they would.
And that's absurd, isn't it?
I'm not going to answer that question.
Right. think I don't really have any further matters than that. Thank you.
Thank you. Committee. Would you like to start?
Kevin.
Thank you. Yes, the figures for the tobacco, which included excise tax, now that you've heard that there should be excise tax, should have been subtracted, do you still make that suggestion that this is, somewhere in your report you say it's a tobacco, it's more of a tobacco store than a grocery store?
I don't believe that I said it was more of a tobacco store. It was more principal sale business. It was actually,
Sorry.
I think it's more of a convenience store. I now can say, yes, my figures aren't correct, but I didn't know that at the time of compiling my information.
Okay, thank you. And the litter problem, which I would suggest anyway, is shared by all the shops in the shopping centre, and the no liquor and the liquor ban. Whose responsibility is it to police the liquor ban area?
The police.
Not the council?
We can't issue infringements for liquor ban issues. It's purely to do with the police.
Okay, so and it's only triggered by a complaint? Could be when you went up there and saw some people, you could trigger a complaint?
Yeah, we could ring up and say there's people outside drinking. Anyone could ring up, but whether or not they have the ability or the time to actually go and actually issue infringements, I don't know.
Okay. Yeah, the single bottle sales is something that's got to me. You don't want to answer whether it's absurd that they can't sell single bottles unless they order them singly. From your experience with the other licences that we have throughout the city, and we have the same, very similar wording about single bottle sales, does that mean that all the units in Porirua now are outside their obligations?
The wording on this licence is actually slightly different to the other wordings. They're a little bit more specific on the other licences. The reason why I didn't answer the absurd thing is I don't believe that I'm in a position to say whether or not it's absurd. I'm not selling or ordering the product. Some suppliers may turn around and say, they want 12 500ml Heineken tins. If it's ordered in 12 tins, that's fine. Comes in a box. But we don't know how, there's no evidence to say how it's actually being ordered. Is it being ordered in packs of 12? It might come in a box, but how is it actually being ordered?
So we don't know if they're meeting their obligations.
No, I don't know. I'm not qualified to say how they might be delivered for ease in a box, but they might not be ordered by the box. I don't know.
Okay, now we're going to have a site visit. You suggest it's not really, it doesn't have the appearance, or in your opinion, it doesn't have the appearance.
No, I didn't say that.
Well, okay, I might be using incorrect terminology. I'm not legally qualified like everyone else seems to be around the table. You've said, let me see if I can find it. In where the premises is a grocery store. I'll try and find what you suggested that it's no longer primarily a grocery store, haven't you? Somewhere.
The activity, correct.
Yeah. So when we go up there, what do you think we should be looking for to confirm what you think, or what the licensee's going to be telling us or showing us?
I think when I went 5 weeks ago, I walked in. It looks like a grocery store. There was the fruit and vegetables. There was all of that information, but I was there for a whole hour. The majority was lotto sales, lolly sales, ice blocks, drinks. There was 3 loaves of bread and 2 bottles of milk. But having a look at it, everything when you walk in is set up for convenience items, whether it be pies, drinks, lollies. You actually have to want to go looking for a specific item to purchase grocery items. So it's further back.
Sorry, but you'll be aware that as a committee, we are not supposed to give any advice on how to set out a retail establishment.
And I'm not asking, you asked me what my opinion was when I came in, that was my opinion.
Yeah, okay. So we should be just, I'm still not sure if I'm,
I don't think we should be asking the agency what we should be looking at when we go on a site visit.
I'm sorry, Madam Chair, but this is part of her, she's saying that in her opinion, it's not set up like a grocery store, isn't that a legitimate question?
It's based on the figures. It's not what it looks
Yes,
like.
that's right.
At no
I was
point
gonna
have
come
I
to
said
that.
it doesn't look like that.
Sure, I was going to come to that. So you're saying you were there for an hour and it didn't look like the figures of the sales of a grocery store, but the figures that we've been supplied with suggest that it could be a grocery store.
The figures
Yes,
we've been
or-
supplied with also doesn't comply with the regulations. It's not for the full period of time that is actually required under the regulations. If you have a look at the figures that were provided at the last renewal, they are extremely detailed under a form that is supplied to pretty much every grocery store around the country. We've had great difficulty trying to obtain the figures for the correct period of time. The figures we have been supplied are random times, and at no time is there a breakdown of any of the bits and pieces, like we had from the manager yesterday. He's putting slushies and foodstuffs, pies, foodstuffs. That's not how the form or the stats or I guess the sales figures should actually be portrayed, because it doesn't fit.
Okay, it doesn't, but aren't these categories what is in the Act?
It's in the regulations, it is correct. And what we've done is the New Zealand Institute of Liquor Licensing Inspectors, and every single council is using them, is to make things easier for the different POS machines and the accountants to actually break down so they can see what is required and defined as a food product, convenience food, breaks down to the size of the ice blocks, the chip, the drinks, everything is quite specific. So there's no confusion what comes under the food products.
Thank you for that. Maybe I should be asking the applicant some more questions. Thank you.
Okay?
I just have a couple of questions. In terms of the observation at your site visit of people drinking outside in a liquor ban area, and I appreciate you not supplying alcohol, but did you at that time call the police or contact anyone in the council to raise that as an issue?
No, I made mention of it when I came back to the office, but that was as far as it went.
Okay, thank you. And in terms of conditions, there's the hours that have been sought, there's some conditions that have been offered, there's already conditions in place. Are there any conditions or improvement on conditions that would satisfy the inspector in relation to the concerns raised about this application?
I think the condition with regards to requirement for a host responsibility, that's pretty big. There clearly isn't a host responsibility policy enforced. It's a requirement under the legislation, and I think there needs to be more detail, even because we're limited to the types of conditions obviously we can put on a condition. In an ideal world, we would need to be, I need to be confident that the staff at the site know actually what they're doing. I had no confidence whatsoever during my site inspection that the intoxicated gentleman walked in. You could see straight away he was non-verbal, only waving his arms, straight to the fridge, actually took the stuff out the fridge, and I'd had to say to the manager, are you going to do something with regards to that? Oh yes, went and said, sorry, we can't serve you, had to escort him off the premises. He shouldn't have got that far. So to me, that's lack of training with regards to the requirements on how to deal with a prohibited person. And it would probably be the same. I'm not saying that they need to turn around and put themselves at risk with these people outside, but they've got to be proactive within what they're doing inside as well. So extra conditions is hard because the conditions that I could probably say, like extra proper staff training and that sort of thing, they can't go on a licence. We could do it as an undertaking, but that can't be enforced.
Those are the only questions that I have.
I just had one question in regards to the incidents book or incidents logbook, which you couldn't find. The incidents logbook, is this where you would have a look at this and record incidents onto a council computer or something like that, so that when you go into the history, those are the types of things that you look at when you're going through the application process?
Yes, so the form that I've attached is the inspection form. In an ideal world, be able to have a tablet, be able to upload it and that sort of thing. The manager I was speaking to, we went through 3 toolkits. There was no, the last incident that I found was 2022. Could not find anything else. There was 3 managers' registers, none of them were up to date. No incidents registered. The 2022 was the last incident recorded in any of the 3 toolkits, and there was no training records whatsoever in any of those 3 training records. So we went through, the poor guy was pulling everything out from everything in the cupboard set of shelves behind him and underneath. We couldn't find a thing. The manager's appointments are also very important beside the incidents as well, to the fact that, okay, with regards to the manager that wasn't appointed, every time he's on duty, a sale of alcohol has been made. It's been done so illegally because he's not an appointed manager. So these sort of appointments and registers are extremely important from my point of view as an inspector. I make note of that on the file, so every year I can establish if there is a pattern, so at next renewal time or what have you, we can see if there was any issues throughout that 3-year period. But with no records whatsoever or incomplete records, it makes it extremely difficult.
Thank you.
Sorry, just to clarify, in terms of that manager, he was a certificated manager, but not one that had been noted as the manager on the record.
That's correct. Okay. He had been appointed at Thirsty Liquor Waitangarua.
Okay. I think we've finished there.
Thank
you
you
very much. Just in regards to the process, we obviously will come to you to make any closing statement, but I'm just wondering if there were any more questions if we got to that stage of the committee.
I think we've generally asked all our questions, and in terms of closings, there will be an opportunity to provide written closings, but Mr. Middlemas, there's also an opportunity to provide a sort of wrap-up closing at the hearing as well.
I mean, that would be great. I would take that opportunity. Yeah.
Okay.
Maybe perhaps after a lunch break.
Lunch break? What is our time? It's midday.
I mean, I think that we can, because we're right now at the end, possibly we can do it and then everybody can go after that. Is that?
Will everybody get a chance to do a closing statement, all the parties?
Do parties wish to provide to wrap up anything they've said verbally in this hearing, or
I'd prefer to do written, please.
They'll be written closings. Okay.
Dr Gordon.
Yes, ma'am, we prefer to give written closings, please.
Okay.
Written.
Mr. Middlemass, I do appreciate though that if you do want to give a verbal closing and you wish to have a bit of time during the lunchtime adjournment, then that should be made available to you.
Thank you. There's just been a lot of evidence and questions today and yesterday, to be fair. So if even just a short break, not necessarily a lunch break, maybe just 20 minutes or so, just to gather my thoughts and put it all in the right order.
Okay.
Okay, well, that's a lunch break, so we'll go at 12 and we'll come back at 12:30 then for your final closing statement.
Right. Thank you very much.
Thank you.
Te runanga o tō rangatira have left the afternoon, so just to let everybody know. Okay. Mr. Minimus, would the applicant like to make any closing statements?
Thank you, Madam Chair. Yes. So I'll just try to use this opportunity to present kind of the elevator pitch for the application. Really try to summarise the committee's task and kind of what we've heard in as accurate way as I can in in that last 20 minutes of just really trying to cram it all into this document. But anyway, the DLC's task here is to consider all the evidence heard. It has heard a lot of evidence, and to weight that evidence appropriately and then to assess it against the criteria of the Act. It must then stand back and check that evidence against the object of the Act, which is of paramount importance in light of the purpose of the Act. One of our submissions made in opening is that the committee ought to treat generalised evidence as general evidence and that should prefer specific evidence about the super-ed itself. There has been a lot of evidence both for and against the application, some of which has been specific, specifically the evidence in relation to drinking outside the premises and litter found in and around the premises, as well as specific incidents in relating to alcohol-related harm in the vicinity, but then otherwise has been largely about alcohol-related harm and other harm occurring in the Cannons Creek and Porirua communities more generally. Now that evidence is relevant, the DLC can and should have regard to it and take it into account. Our submission is really just that it's a weighting issue for the DLC to determine, but it is certainly relevant to the next part of this my closing that I'm going to talk about, which is, as Dr. Palmer referred to earlier, it's that Lion Liquor case in the High Court. So in that regard, in relation to this decision, that generalised evidence is relevant, is very relevant, but in relation to the context of the application as a whole, the generalised evidence becomes less helpful when you're doing your evaluative and merits-based assessment of the super-RETS application. So in that Lion Liquor case, as Dr. Palmer set out, the High Court found that where alcohol-related harm is occurring in and around a premises, that premises is then implicated in that harm, and at that point the DLC can take steps to address that harm. And in that case, the DLC decided a step it could take was to reduce the licensed hours on Friday and Saturday nights by a few hours. And so effectively, what steps this DLC might take will depend on the level of harm that it sees occurring on the evidence. But this kind of comes from the precautionary principle, which is a principle in environmental law, that you are entitled to test whether a certain restriction might help to curb harm. You don't just have to sit there and say, well, don't know what you want us to do about it. You can act, and you can, as long as you're according with the principles of natural justice, you can limit how an applicant sells alcohol using that principle. Our submission is just that any restriction that you look to put in place should be reasonable, and that's in line with the purpose of the Act, which is to create a reasonable system of control over the sale of alcohol. So while the object of the Act is clear, and we all know that it's about alcohol-related harm minimisation, there is also the counterbalance, which is that the system needs to be reasonable. And where there's principally or a lot of concerns being raised about the community generally, which are relevant, like I said, and go to this precautionary principle being triggered, that just shows that it's harder to, maybe I'll put it another way. It's really just the focus is that the restriction should be reasonable and given and fit for the circumstances and the harm that you're seeing. So and yes, that pathway is open to this DLC here as well if it finds that the premises is contributing to the alcohol-related harm occurring. The evidence of the witnesses shows that members of the public, have look to have breached the alcohol ban by drinking outside the superette, as well as litter being found around the premises and further afield. And as put to Dr. Palmer earlier today, while these are harms, this is alcohol-related harm, these are not the most serious types of harm that could occur from alcohol-related, for alcohol-related reasons. So it's important that the DLC kind of places that level of harm, as I said, when determining the steps it should take or might take to restrict the license in accordance with the precautionary principle. So the level of harm is important that you can specifically tie to the premises, I would say. The more that the committee can tie like serious harm to a specific premises, the more severe its restrictions should be. And I think I made the submission in my opening that if the harm occurring is incredibly serious nearby a premises, then it might be that restrictions simply won't work, and that the DLC's choice there would be to refuse the renewal. In my submission, that's not the case here. We're looking at a lower level of harm. While it's not good and it's concerning and it's something that needs to be addressed, there are more proportionate ways to do that than by refusing the renewal. Now, in relation to the grocery store requirement, we have heard evidence, some from Ms. Burt today, that the premises now looks like a grocery store. Mr. Patel has given evidence to the committee that it does sell products, a lot of products commonly found in grocery stores in New Zealand. The form that Ms. Burt has provided as an exhibit today, in my submission, goes beyond what's required in the regulations, which only say that you must set out the 5 different categories. However, I think it is possibly quite helpful, and as part of the things that my client's willing to kind of propose, I can discuss them later, but it might be that the DLC may prefer to have a new statement of annual sales revenue produced, which just more clearly breaks down these matters, because it may be of more assistance to the DLC. In relation to, I guess now turning to the criteria, I'll only discuss a few because I don't want to take forever doing this, but probably one of the key ones is suitability. So we're, again, on the law that I've referred to in my opening, states quite clearly that if the DLC finds a community is vulnerable, it's likely that the threshold for suitability will increase. Now, the evidence the DLC has heard through the course of the hearing, I would say, has not raised any significant suitability concerns, such as dishonesty, convictions, breaches of alcohol licensing laws, as in the most serious ones, sales to minors or intoxicated persons. The evidence has really been more about errors with its application form, perhaps sloppiness, administrative record keeping, and failure to notify changes in management, which is a common issue for licensees across the country. But these are matters that are relevant to suitability and should be taken into account by the DLC. But again, these are not significant factors that go against the applicant's suitability. Not certainly enough, in my opinion, to render them unsuitable, even at an elevated threshold, in the absence of that other, more damaging suitability evidence. Coming now to, I really will just probably move on now just to kind of forward-looking exercise of setting out and summarising the things that the applicant is willing to do or to have imposed on its licence, in the hopes that the concerns will be addressed appropriately and that the DLC may impose those restrictions in accordance with the precautionary principle. So just to summarise these, the applicant was willing in evidence to reduce the licensed hours for the premises so that the opening starts later. I think 10 o'clock or 10:30 a.m. was what Mr. Vishwakarma said in evidence. The proposed variation, the current one, was to reduce the single alcohol area, but given the evidence received that the even varied area would still be a larger area than is normal for a grocery store that size, the applicant would be willing to restrict that size of that area further. Also would be willing to have a more restrictive single sales condition, whether the DLC is minded to do so, it may go so far as to restrict single sales of beers from the premises and ciders. I note that the LAP, as I referred to in my opening, the current LAP has a discretionary condition the DLCs can apply around litter cleaning up around the outside of the premises. The client would consent to that one as well, or a condition of that kind being implemented, and also would be willing to have a condition stopping it from using Afterpay for alcohol sales. On top of that, another proposal would be to have for the committee to look at a truncated renewal, so it would only renew for 2 years, which would effectively take us to 27 April 2026, which would be another opportunity to see whether any of these restrictions have actually addressed the harm or improved the situation at all. And along with those things, there's other steps which might be the subject of undertakings that the applicant is willing to use. It does have CCTV cameras outside the premises, but it's willing to install a dedicated monitor inside so that it can see that outdoor area while staff are at the bar. At the counter, and then if they need to, they can call the authorities. They also will continue with their practice of warning drinkers or customers that are going outside that they can't drink outside, and if they are caught breaching the alcohol ban and they don't stop, the superette may trespass them and may include signage in the superette to that effect. As I said earlier, they would be willing to provide a more broken down statement of annual sales revenue that goes beyond the regulations if it would assist the DLC, and to provide a copy of the incident log, I believe that was requested. And I think that encapsulates all of the things that the applicant is proposing to do. So just really now, last thing is just in terms of that object of the Act check. The DLC can now have regard to all of the evidence as well as the things I've just said that the applicant is willing to have imposed on its license, or steps it's willing to take, positive steps it's willing to take. The DLC can stand back and in our submission can be satisfied that this application is capable of meeting the object of the Act. Thank you.
Thank you, Mr. Minimus. We will invite everybody to submit their closing submissions. What kind of timeline, what kind of timeline and what would work in regards to sending through your closing submissions?
The idea would be to have the agencies and the opposers making closing submissions first, and the applicant having the final right of reply in terms of closing submissions. That said, there has just been an offer to perhaps, if required, provide further sales information or further broken down sales information. We have had 2 days of hearing, and that's given parties an opportunity to discuss the information that is available. Some further sales information there wouldn't be an opportunity of discussion, but there could be submissions made on it and closing submissions through parties. With the sales information, Mr. Miromas, we've got sales information for 2023, there's sales information for another period from 2024. In terms of the proposal to provide new sales revenue information, would it be for another period, would it be for the same period, or would it just be broken down information for one of those periods?
I think it would be the only way it would be possible, from my understanding of their having lost the data when they did the switch of point of sale system, would be that it would likely just be for that same period as the table inserted as an exhibit to Mr. Vishwakarma's evidence, which was June 24 to May 25. Yeah, okay. It would just be a more detailed breakdown for the committee to understand the revenue streams.
Okay.
And I also understand that would be available quite quickly, which could then be distributed to the parties, and they could then make submissions on it in their closing.
Okay. I think it would be helpful to the committee to get some further breakdown on that information. So you're saying that could be available quite quickly. What are we talking, a week, 2 weeks?
I think faster than that. Are we talking within a week? Within a week. Okay. To be safe, within a week should be available.
Okay, and so copies of the incident log as well would also be available?
Yes.
Okay, within that time frame. Okay, and then it would be an opportunity for all other parties to provide closing statements which could cover information, any responses to this additional information that's being provided.
I'm just wondering if we could have a copy of I'm not too sure, the ability of the submissions that were just made, if we could have them in written form with the proposed conditions on them.
Yeah, and because the applicant will have an opportunity to provide, actually, because then you could comment easier on that, you're saying, okay, all right. So yes, perhaps if that could just be provided
That
as
came
well.
with it? Yeah.
Yes,
Yeah, that's
yes.
fine.
I was going to ask whether, I understood that Mr. Middlemas's oral submission was sort of a summary, and that he may wish to write a more detailed closing submission, which then we could look at.
He'll have an opportunity to do that, but because the applicant has a final right of reply,
Yes.
I think the better approach is to have parties file written closing submission, and then the applicant filing a closing submission after that. Although the benefit of having the oral summary today is providing parties with an outline of what the applicant's overall position is in relation to its application, given that we've just had a day and a half of hearing the information and the evidence.
Is it possible for the brief summary of what the conditions proposed, you agreed to today, be attached to the incidents register and the figures, and they just be all submitted at the same time?
That's what I understand Mr. Middlemas has
Perfect.
just said, that
Thank
he can
you.
give that
Thank you.
summary of what he's just given today, and that you'll have that in written form as well when you're putting together your closing submissions. So then the next question is, what's a workable timeframe for you to provide after the week, when in a week's time you'll receive this further information? What after that is a reasonable timeframe for you to write up some closing submissions if you wish to do so?
Sorry, Dr. Gordon, do you have any questions?
I have a question, ma'am, and also an estimate of time. So the question is that I'm concerned that the quality of the figures that are being provided clearly makes the distinction between grocery food items and convenience items, and there's been no undertaking that will be the case. If that's not the case, then the question of whether the basic requirements of being a grocery store is met cannot be determined by the figures. So it leaves it very much up in the air. So I'm very concerned that the order is given that those figures provide that clear distinction between food items and convenience items according to the requirements under the legislation. So that's that point. And then once Mr. Middlemas's summary, the figures and any other materials are received, Dr. Hewison would probably prefer, if it's acceptable, a period of about 2 weeks to write his final statements.
Thank you, Dr. Gordon.
Thank you. So Mrs. Kelly is mentioning a time frame of 3 weeks, did you say?
In total.
Oh, okay, in total. Okay. And for the other agencies, what is the time frame? I do appreciate that some people are busy.
I'm happy with the 2 weeks after we receive the information, but what the doctor just said, I was actually quite right, because we were told yesterday that the way it's scanned, things are like slushies are put into foodstuff. So how do you know that it's a true breakdown? That's my concern.
At the end of the day, the committee can only make a decision based on the information that it has in front of it. So if the sales information isn't getting the information that we need to do, then we have to make decisions about that. But at the moment, we've got some sales information. We've got some more coming in. We also have views about that the sales information that have been pointed out in this hearing. What can be done at this stage is the applicant can provide further information. It's, I guess, another opportunity for it to do that. And then all other parties can provide their thoughts and comments on what's in there and how far it goes or doesn't. And then it's for the committee to make a final decision on what weight it applies to everything and how it's going to assess whether the sales information confirms that the applicant is a grocery store still or not. Yeah. Okay, so 2 weeks. Dr. Palmer, is 2 weeks sufficient? Okay. And then, Mr. Middlemas, in terms of a final closing submission in writing, you don't have to provide one, but you will have an opportunity to do so. What would be a workable timeframe for that?
I think perhaps just an additional week.
Okay.
Yeah, I can begin
Okay.
earlier, I don't have to wait
Okay.
for the others to get started, so I think that's reasonable.
Okay. So that's then 1 week for the further information from the applicant, plus a summary of their closing that they've just made today. 2 weeks for all other parties to provide their written closing submissions in response to the further information, and then a final week for a final closing submission from the applicant. Okay.
Are we all in agreement with that? Dr. Gordon, you're in agreement with that?
Yes, ma'am.
Okay, and just one final matter. Our plan is to do a site visit right after this hearing, if that's possible. Is that something we can do?
Yes.
Okay, thank you.
Okie doke. So wait, did you want to? Oh, okay, good, sure. We have reached the end of our hearing, day 2. I do actually want to thank the applicant, the agencies, the objectors, the council, and the public gallery for being with us over the last couple of days. There was a lot to take in, and it was certainly a long day yesterday. But I actually want to thank you all for your time, and we will end with our closing karakia. So join it. Kia hora te mari, kia whakapapapona mu te moana. He. Aroha atu, aroha mai, tātou I a tātou katoa, huie tā e ki ue. Go well.